Let us read a case involving boundary dispute. Okay. So, the resolution of a boundary dispute by reason of the issue therein being whether or not the contested portion pertain to one or the other of the parties is not, what daw? Gawas, is not within the province or not within the coverage of the summary action of forcible entry. Under Rule 70 of the Rules of Court, it can be taken proper cognizance of in the context of action reivindicatoria. So, different ang remedy. Dili daw forcible entry. Ato tanawon, unsa ang facts of the case, no? Unsa ang naitabo ning kasuha. Kay namoy pronouncement or na doctrine in a case, but di mo na ma-apply sa lain nga sitwasyon kung different ang set of facts, no? Lahi ba? So, sometimes, siguro mo shoot ang doctrine, pero maniguro ka, tanawon yun na to ang istorya para sakto ang context sa ato ang pag-recall, pag-learn sa doctrine, and possibly pag-apply. No? The petitioner hereby appeals the decision promulgated by the Court of Appeals, affirming the judgment rendered by the Regional Trial Court, ordering her and all other persons acting for and in behalf to vacate the part of the premises covered by a tax declaration originally issued, wait lang ha, na chat. TikTok. So, ang yuta diri so far, more tax declaration na siya, walay titulo, no? Kay ang gi-refers, ang document nga gi-refer diri is only tax declaration. Wala may naka-mention sa decision nga titled, no? So, there was an order, no? Ordering her and all other persons acting for and in her behalf to vacate the part of the premises covered by a tax declaration originally issued in the name of the heirs of Socorro Lim and to turn over its peaceful possession to the respondents. Antecedents. The factual and procedural antecedents of the case are summarized as follows by the Court of Appeals. This case emanated from an action for forcible entry with prayer for issuance of writ of preliminary injunction filed by herein respondents, heirs of Rimberto Lim against petitioner Martinez. Respondents are the heirs of Lim who, during his lifetime, owned, possessed, and cultivated a parcel of land, no, located somewhere in the Philippines, covered by tax declaration. Adjoining Rimberto's land is the land of his brother, Jose. No? So, adjoining Rimberto's land is the land of his brother, Jose. So, sikbit. No? Ang kasikbit siyang yuta. Registered under an OCT. It is worthy to note that per the technical description in the said title, the property is bounded on both the east and west by the properties of the heirs of Socorro Lim, which were later on acquired by the late Rimberto Lim. Okay. As it happened, Jose sold his land covered by an OCT, original certificate of title, to a certain medalla, who thereafter subdivided the same into two smaller lots, designated as lots 1 and 2. Lot 2 was further subdivided into 9 smaller lots, this time designated as lots 2A to 2I. A, B, C, D, E, F, G, H, I. Okay. So, 9 resultant lots, no? 9 smaller lots. Lots 2D, E, and F were thereafter sold to herein petitioner Martinez pursuant to 3 separate deeds of absolute sale, and by virtue thereof, petitioner Martinez was issued 3 transfer certificates of title in her favor. Later, petitioner Martinez and her father entered into the property and uprooted some of the acacia mandium trees that were previously planted thereon by the late Remberto Lim and his son, yung anak si Alan. To further delineate their claimed property, petitioner fenced the same and placed signs thereon that read, "No trespassing. Notice, this property is owned by the Martinez family." Now then, claiming that petitioner had unlawfully encroached into a portion of their property, respondents through counsel sent a demand letter to petitioner demanding that she immediately remove the fence that she built on respondent's land, as well as to turn over peaceful possession of that portion of property that petitioner intruded into. Unfortunately, the demand was ignored by petitioner and respondents were constrained to file the instant complaint for forcible entry with prayer for issuance of writ of preliminary injunction against petitioner before the Municipal Circuit Trial Court, so first level court. In its decision, the Municipal Circuit Trial Court ordered petitioner, among others, to vacate. Okay? So, i-order ang petitioner to vacate and turn over peaceful possession of the disputed portion of the property. In its ruling, the Municipal Circuit Trial Court examined petitioner's title as well as those of her predecessors and concluded that when the Medalla spouses subdivided Lot 2 into 9 smaller lots, they erroneously included a portion of Socorro Lim's property. Specifically, the Municipal Circuit Trial Court noticed that in Jose Lim's title and the resultant titles issued to the Medalla spouses, their property was bounded on the east by Socorro Lim's property. However, in the titles for lots 2A until 2I, nakasequence man ang resultant lots, 2A, 2B, 2C, until 2I, inclusive, the properties became bounded on the east by the Mabintangan Road, which was supposedly the eastern boundary of Socorro Lim's property. As such, despite petitioner's titles over the property, the Municipal Circuit Trial Court awarded possession de facto to respondents and consequently ordered petitioner to immediately vacate and turn over peaceful possession of the disputed portion to the respondents. On appeal by petitioner, the Regional Trial Court affirmed in full, in toto, the disposition of the Municipal Circuit Trial Court. Petitioner then filed a motion for reconsideration thereof, but to no avail. The petitioner timely filed an appeal. What is the decision of the Court of Appeals? In the now assailed decision, the Court of Appeals opined that in ejectment cases, the better right of possession was primarily associated with a party who could prove prior physical possession of the property in dispute. That the respondents had a better right of possession over the disputed portion on account of priority in time, considering the following documents submitted as evidence by the respondents, namely, number 1, tax declarations in the name of Rimberto, from whom the respondents had inherited the portion in dispute. Second, a tree plantation record form. Third, the memorandum issued by the Senro certifying that the acacia mandium trees and mahogany species were planted by Rimberto's son, Alan Lim, on the land covered by the said tax declaration issued in the name of Rimberto Lim, and that it was evident that neither Jose nor the Medallas, Dorothy and Alexander, from whom the petitioner had derived her title, had dominion over the disputed portion, thus warranting the logical conclusion that said portion had been erroneously included in the titles issued to the Medallas. So, na ay logical conclusion daw that the said portion had been erroneously included in the titles issued to the Medallas. So basically, na-appeal dito sa titulo ang yuta nila, no? Na-appeal sa titulo sa laing tao, nakayuta, na-appeal og titulo sa laing tao. That is not uncommon, no? Samot ng, let's just say, unay sayop ang katong cadastral survey, ang yuta ni Pedro na-appeal dito sa yuta ni Juan. Pagpatitulo ni Juan, nigawas ng titulo, na-appeal sa titulo ni Juan ang yuta ni Pedro. Gidako ng gubot. The value of the decision of the Court of Appeals reads, wherefore, foregoing considered, the petition for review is denied, the decision of the Regional Trial Court is sustained, so ordered. The petitioner moved for reconsideration, but her motion to that effect was denied. Hence, this appeal issues. The petitioner poses the following issues, namely, the court erred in upholding the trial court's particular finding that respondents supposedly have better and or superior right of possession over the contested properties, notwithstanding that the petitioner's claim of ownership over the subject properties is supported by a torrents title to her name. The court erred in upholding the trial court's particular finding that the petitioner's certificates of title encroach on the respondent's putative property. The court erred in upholding the trial court's finding that the respondents are the heirs of the deceased Remberto and that the property being claimed by them belongs to the estate of the said deceased. Next, the court erred in upholding the validity of the complaint, notwithstanding the failure of all the herein respondents as plaintiffs in the forcible entry case to sign the requisite certificate of non-forum shopping attached to the complaint. The court erred in not finding the respondents guilty of forum shopping and in failing to order the dismissal of the complaint on this additional ground. In the resolution, the court denied the petition for review on certiorari for its failure to sufficiently show that the Court of Appeals had committed any reversible error in promulgating the assailed decision and resolution as to warrant the exercise of the court's discretionary appellate jurisdiction. Undaunted, the petitioner filed a motion for reconsideration, arguing that the Court of Appeals had grossly erred in refusing to acknowledge and recognize her torrents title as proof of her superior right to the possession of the disputed portion, and that the decision of the Court of Appeals, like the previous decisions of the lower courts, constituted a quintessential collateral attack on her various certificates of title. In a resolution, the court granted the petitioner's motion for reconsideration, reinstated the appeal, and required the respondents to comment on the petition for review on certiorari. The respondents submit in their comment that the land covered by the tax declaration had been included in the titles issued to the petitioner, who was consequently illegally and unlawfully occupying the same, that they were still the lawful owners of the land illegally and unlawfully included in the titles of the petitioner, that they had a better and superior rights of possession over the land covered by the subject tax declaration, and that they substantially complied with the rules on certification on non-forum shopping. Let us read the ruling of the Honorable Supreme Court. We find merit in the appeal. Preliminarily, this court discusses and distinguishes the three types of possessory actions sanctioned in this jurisdiction, namely action interdictal, action publicana, and action reivindicatoria. Okay? So, action interdictal is a summary action. So, summary action that seeks the recovery of physical possession. So, tulo ka klase, natay action interdictal, action publicana, natay action reivindicatoria. So, si action interdictal is a summary action that seeks the recovery of physical possession where the dispossession has lasted for not more than 1 year and is to be exclusively brought in the proper inferior court, Municipal Circuit Trial Court, Municipal Trial Court, Municipal Trial Court in cities, first level courts. The issue involved is the material possession or possession de facto, Dili siya in contrast to legal possession. The action is either forcible entry or detentation or unlawful detainer. Disu, witcho. Hindi ko mabasa. No? Detentation. Ang ako nailhan ni forcible entry or unlawful detainer. Namun siya yung mga Latin names. In forcible entry, the plaintiff is deprived of physical possession of real property by means of force. No? Kanang kaliton og sulot ni mo ang yuta. Mukalit og suod sa imong yuta. Kuralan. Or nilarga kag abroad, nagbakasyon ka, nag-cruise ship, 1 month, pagbalik nimo, imong yuta, katunga na lang, gigikural na sa silingan, nga na, pwede na siya forcible entry. Dili siya by means of force, pwede siya through stealth, strategy, or pwede ka hulgaon, no? Dutukan kang pusil. Hawa diha, pasudlami, amo ning kuralon. Intimidation, no? Threats. So, but in a lawful detainer, the defendant illegally withholds possession of real property after the expiration or termination of his right, no? Na-impas na iyang katungod to hold possession under any contract, express or implied. So, normal ni siya. Like, for example, gapaabang kang property, gapa-rent, na-expire na ang lease contract or wa siya kabayad sa lease, ni-violate siya sa contract, imo siyang papahawaon. No? So, the two are distinguished from each other in that in forcible entry, the possession of the defendant is illegal from the beginning and that the issue is which a party has prior de facto possession. While in unlawful detainer, the possession of the defendant is originally legal but becomes illegal because of the expiration or termination of the right to possess. No? Originally legal pagsugod, yan nahimong illegal. Kay ni-expire imong katungod or nawala na, no? Na-terminate na inyo ang kontrata sa imuhang paggamit anang yutaa. Ang forcible entry, from the very beginning, illegal yun. For example, no, mo lagi na, gitutukan kang pusil, gipaatras ang imong kural, kay ni kural imong silingan og bago, giirog ang inyong utlanan. So, kana, possible na siya, nga forcible entry. Or, nilarga ka, nag-abroad, nag-cruise ship, nagbakasyon, pagbalik nimo, nanay concrete fence, imo yuta, katunga na lang nabilin, nakural na sa silingan. Okay? Or, pagbalik nimo sa inyong lugar, imong gikural ang imong fence, ay imong gikural imong yuta, nakay fence, nay gate. Pagbalik nimo sa imong yuta nga bakante, nanay balay sulod, ang lock sa gate, dili na imuha, lahi na yung nakalock sa gate, yan nanay butang na, no trespassing, lahi na pangalan nga tag-iya, kaya pwede gyapon na forcible entry. No? Ang importance lang ani kay forcible entry, ma-file nimo within 1 year from the time the cause of action accrues. So, kung nilarga ka abroad 10 years, magbalik nimo, di pa ka nakadiscovery, no? From discovery. So, di pa masugod ang 10 years. Pero kung katong panahon nga, gi-invade ka sa katong nikawat sa imong property, no? Nga nipugos og suod sa imong property sa intruder, the moment nga nahibaw ka sa iyang pag-intrude sa imong property, diha magsugod imo sa katuig. So paspas jud kag file. The two are distinguished from each other in that in forcible entry, the possession of the defendant is illegal from the beginning and that the issue is which a party has prior de facto possession. So prior physical possession. Ikaw gakupot ba? While in unlawful detainer, the possession of the defendant is originally legal but becomes illegal because of the expiration or termination of the right to possess. Both actions must be brought within 1 year from the date of actual entry on the land by the defendant in case of forcible entry, and within 1 year from the date of last demand in case of unlawful detainer. The jurisdiction over these two summary actions lies in the proper municipal circuit trial court of the municipality or city within whose territory the property in dispute is located. So kung asa located nimo ang yuta nga giskwatan or forcibly enter sa intruder, no? ang korte nga na jurisdiction anang lugar mo, dito nimo i-file. Pero dito sa first level court, no, municipal trial court, jurisdiction of the metropolitan trial courts, municipal trial courts, and municipal circuit trial courts sa aning panahon na, no, exclusive original jurisdiction over cases of forcible entry and unlawful detainer, provided that when in such cases the defendant raises the question of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership. Muna ito requirements, no? Kung i-resolve sa court ang ownership, kailangan the defendant raises the question of ownership first. Second, the question of possession cannot be resolved, no? Di siya masulbad without deciding the issue of ownership. Then the issue of ownership shall be resolved only to determine the issue of possession. Aksyon publisyana, malampas ka 1 year sa yung forcible entry, pasok na kay ka, dito na kasunod, aksyon publisyana is the second possessory action. It is a plenary action to recover the right of possession, and the issue is which party has the better right of possession, possession de jure. It can be filed when the dispossession lasted for more than a year. Manino? Pasok. Lampas na kasao sa katuig. Nindo tong forcible entry kay summary proceeding, paspas, makakaon mo sa oras sa kaso, kanaging, let's say, plaintiff, 5 ka witness, defendant, 5 ka witness, pila ra ka hearing sa usa ka tuig, 3, 4, ya mag-resetting pa, ma-absent pang witness, ma-absent pang abogado, pila ra ka witness mo ma-present sa usa ka tuig, 2, or malas-malason jud usa, wala. So, abtan na po katuig imong kaso, napaka sa municipal trial court or sa regional trial court. So, mo na nga nindot kung within 1 year, dito ka sa forcible entry. Ang nakalisod lang na diyang lugar, ano, makatiming kag mga bakakon, nga may kay mamakak. Affidavit ramang god, di ka maka-cross-examine ba, no? Pwede lang ka mag-file or mag-submit og counter evidence. Ang problema, na may panahon niya, why CCTV, why video. Istorya niya o istorya nimo puros laway. May kito mo makak imong kalaban, isog kayo di mahadlok mag commit og perjury, false testimony. Medyo lisod-lisod. Mo'y nakanindot pod kung aksyon publisyana. Kay ordinary civil action man no? So, civil procedure ni sumulingkod diha sa witness stand ang testigo, maka-cross-examine ka. So, kanang pagpamakat, dili ana kadali, not so easy. So, it can be filed when the disposition lasted. So, kung ang dispossession lasted for more than 1 year, no, di na siya mo shoot sa forcible entry. Diri na ka sa action publisyana. The second possessory action. It is a plenary action, no, full action to recover the right of possession. And the issue is which party has the better right of possession. Possession de jure, no? Dili na siya possession de facto. It can be filed, it can be filed when the dispossession lasted for more than a year. It is also used to refer to an ejectment suit where the cause of dispossession is not among the grounds for forcible entry and unlawful detainer, or when the possession has been lost for more than 1 year and the action can no longer be maintained under Rule 70 of the Rules of Court, no? The objective of the plaintiff in action publicyana is to recover possession only, not ownership. The last possessory action is action reivindicatoria or action reivindication. It is an action whereby the plaintiff alleges ownership of the parcel of land and seeks recovery of its full possession. The issue involved in and determined through action reivindicatoria is the recovery of ownership of real property. This action can be filed when the dispossession lasted for more than 1 year. For purposes of determining the court that has exclusive original jurisdiction over action publicyana and action reivindicatoria, Section 33.3 of BP 129 as amended expressly states, mo na yung balaod aning panahon na sa kaso. Section 33 jurisdiction of metropolitan trial courts, municipal trial courts, and municipal circuit trial courts in civil cases. Metropolitan trial courts, municipal trial courts, and municipal circuit trial courts shall exercise exclusive original jurisdiction. Dito ni mo i-file, dito magsugod, original jurisdiction, exclusive, siyara, no? Exclusive, waylain, in all civil actions which involve title to or possession of real property or any interest therein, where the assessed value of the property, dili market value, assessed value of the property or interest therein does not exceed, in this case, 20,000 pesos, or in civil actions in Metro Manila where such assessed value does not exceed 50,000 pesos, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs, provided that in cases of land not declared for taxation purposes, the value of such property shall be determined by the assessed value of the adjacent lots. So, kani siya nga balaod, mo na siya ang existing at the time nga na-file ning kasuha. Okay? The determinant is the assessed value of the property subject of the dispute, not the market or actual value thereof. Commonly nga sayop, no? Madismiss ang kaso. The assessed value of the real property is the fair market value of the real property multiplied by the assessment value. So, dili na siya parehas. It is synonymous to taxable value. In contrast, the fair market value is the price at which property may be sold by a seller who is not compelled to sell, wa gipugos, and may be bought by a buyer who is not compelled to buy, wa pud siya gipugos, no? The jurisdiction of the court over the subject matter is determined by the allegations of the complaint, irrespective of whether or not the plaintiff is entitled to recover upon all or only some of the claims asserted therein. As a necessary consequence, the jurisdiction of the court cannot be made to depend upon the defenses set up in the answer or upon the motion to dismiss, for otherwise, the matter of jurisdiction will become almost entirely dependent upon the defendant. If the nature of the action pleaded, as appearing from the allegations in the complaint, determines the jurisdiction of the court, the averments of the complaint, and the character of the relief sought are to be ascertained. Verily, the body of the complaint, not its title, fixes the nature of the action. Kaya syempre, ka na mag-file tang complaint, ang abogado, titulan man na unsay pangalan si mong kaso. Sometimes, ang title, sayop, dili mao sa unod, sa lawas sa complaint. So, the complaint for forcible entry filed by the respondents contained the following pertinent allegations to wit. Paragraph 3, that during the lifetime of the deceased Remberto, he was the owner, claimant, actual, open, adverse, and public possessor, occupant, and cultivator in the concept of an owner and against the whole world of a parcel of land containing an area of XYZ square meters, more or less, situated somewhere in the Philippines, covered by a tax declaration, and more particularly described as follows. A parcel of land located somewhere here, somewhere there, no? Designated by assessor's lot number, containing X number of square meters, bounded on the north by na lot number, on the east by another assessor's lot number, on the south, assessor's lot number. Timan-ani mo sa inang lot number, sa assessor, lahi na sa cadastral lot number, kana nasa titulo ni mga lot number. No? Kaya napoy lahi nga numbering ang municipal or city assessor, yan napoy lahi nga numbering sa cadastral lot number. Mano makita ka sa deklarasyon, lot number, usually, unless gibutang dito nga assessor's lot number, cadastral lot number na siya. Nga sa ubos, cadastral survey number. Mo na siya ang katong number na nag-designate sa specific cadastral survey. Usually, kada lugar, na dyan ay at least one o sahay duha. Depende kung ikapilagi cadastral survey ang usa ka lugar, portion by portion. So, mo na mo makita sa deklarasyon. So, declared for taxation purposes in the name of Remberto as shown by a copy of the tax declaration. So, Ang assessed value na po what? That the above described parcel of land is a portion of that bigger parcel of land covered by another tax declaration, while the land covered by the other tax declaration is a portion of that bigger parcel of land. So basically, i-describe din yun sa yuta nga gikaso, no? Di lang nato i-go into detail kay iya lang i-describe nga. Kani nga deklarasyon mo yung dako, kani siya portion, no? That Jose Lim was able to secure a title in his name over a portion of the land covered by a certain tax declaration under OCT copy of the title to attach. So, kani siya nga part sa complaint. Basically, gasulti siya nga. Kaning tibok yuta, mo ang titulo, no? Siguro, pag cadastral survey, nasayop na ang yuta ni Pedro, na-appeal sa yuta ni Jose. Tibuok ba? Dapat ato na separate siya og cadastral at number. So pagpatitulo ni Jose, dili ma-appeal og patitulo ang yuta ni Pedro. So pag cadastral mo, mamabadli si nalimtan. Nahimong tibuok nga yuta na approve. Pagka-approve pagpatitulo ni Jose, ang yuta ni Pedro na-appeal siyang titulo. Mo ni siya nga sitwasyon. That during the lifetime of Humberto Lim, one of his sons, they planted several seedlings of acacia trees inside a portion of the land. Kani siya more of to prove possession, occupation, no? Open, continuous, exclusive, notorious possession and occupation or control over the property in the concept of an owner. So, yun sa man mo pag-possess, yun sa mo paggamit ang property. Nananom kong kahoy, akong gitugwayan og manok, gitugwayan og baka, gibutangan og tangkal sa baboy, diha ko gapuyo, ako'y gauma diha. So, mo ni siya nga type of allegations. Di na ito basahon. Ilahan mo ng storya, no? So, tanaw na to sa doctrine. Mauro may nakataas. So, based on the aforequoted allegations of the complaint, ako na lang skip ang allegations sa complaint, ha? Ato lang balikon o basa kung mo refer diri ang decision sa Supreme Court on a specific part of the complaint na may mga provisions sa complaint nga gi-file sa plaintiff diri akong gibasa og pinaspasay. Basically ang punto ra ang yuta ni Pedro na appeal sa pagpatitulo ni Juan, mora to, no? So based on the aforequoted allegations of the complaint, the decisive issue is whether or not the forcible entry case under Rule 70 was the proper remedy to resolve this controversy. Sa kadto nga sitwasyon, no, ang yuta ni Pedro, tungod kay wa siya ma-separate og lot number pagkadastral, na-appeal sa yuta ni Juan. Pagpatitulo ni Juan, na-appeal ang yuta ni Pedro sa yuta ni Juan. Now, karon ang question, sakto ba nga remedyo ang forcible entry? Kinisod naman tong si nakapatitulo. Kato nakapatitulo ni sud na siyuta atong yang sikbit kay naapil lagi sa iyang titulo pagpasukod, no? Sakto ba nga remedyo ang forcible entry case? We rule that it is not, no? According to the Honorable Supreme Court. A proper reading of the allegations of the complaint shows that the case revolved around the actual metes and bounds of the parties' respective properties. The complaint was anchored on the theory that the properties registered in 3 certificates of title issued in the name of the petitioner had erroneously included portions of the property covered by the tax declaration issued in the name of the respondent's predecessor in interest. So, na portion nga na-appeal, no? Although, usahay po na ang rason na magsapaw, no? Magsapaw ang mga yuta ba? In contrast, niya common din kana magsapaw, naka sa boundary sa munisipyo, boundary sa city, no? Let's say, barangay ABC, barangay DEF, imuyuta na diya tungod, posible kayo magsapaw. Or, municipality apple, municipality banana, imuyuta na sa tunga, sa duha ka munisipyo, posible kayo magsapaw. Huwag imuyuta, ginagmay ra, mawa, no? So, a proper reading of the allegations of the complaint shows that the case revolved around the actual metes and bounds of the parties' respective properties. The complaint was anchored on the theory that the properties registered in 3 certificates of title issued in the name of the petitioner had erroneously included portions of the property covered by the tax declaration issued in the name of the respondent's predecessors in interest. In contrast, the petitioner hinged her right on the indivisibility of her torrents titles and relied on the technical descriptions of the boundaries of her properties as stated by metes and bounds contained by her titles. Thus, her answer to the complaint relevantly represented. No? Basically, iyang gisaligan na ni common man no? Ikaw, file kang kaso kay, uy, ako man yung yuta, anong imo man yung giapilan og muhon, imo man yung gikural og apil, tipinsas pikas. Bay, pagpalit na ko na apil na sa kuang titulo, diha nga porusyon na technical description. So, problema na, no? Although, kana usahay, guyuron mo na gamay, so magirog-irog sa nangutlanan, depende sa magsukod. Kay lain-lain og ginagamit nga reference points. So, ang iyang dipinsa nga rin, na ihang titulo, iyan ang yuta, apil na siyang titulo, no? At putlo ng basa siyang defense. Kaya ang punto ra, akong titulo na technical description, kana nga portion na sud na sa technical description sa akong titulo. Okay. Logically, from this set of evidences, it can be deduced that a part of the property being claimed by the heirs of Socorro had been included in the lots that were titled in the name of the defendant. This is because when the technical description over the titles of the defendant were issued, the boundary on the eastern side that should have been in the name of the heirs of Socorro Lim no longer exists, but is now bounded immediately by the road. Hence, plaintiffs have sufficiently established that, as predecessors in interest, they have the right to claim and possess such part of the property of the defendant which should still be in the name of the heirs of Socorro Lim as originally reflected in the previous titles of the medallas. As successor in interest of the medallas, defendant could only acquire the property of the former, which originally did not include that part of the property of the heirs of Socorro Lim, and is now the subject of this dispute. Notably, plaintiffs in this case are not claiming the whole property of the defendant, portion lang, but only that portion which should still belong to their predecessor in interest and is now covered by the titles in the name of the defendant. Naapil lang yun, naapil. Wa tatoy labot, no? Nasipyat pagsukod. The foregoing ruling was plain error. What the Municipal Circuit Trial Court should have quickly seen was that the dispute did not concern mere possession of the area in litis, but the supposed encroachment by the petitioner on the portion of the respondents. In other words, the question focused on whether the property being claimed and occupied by the petitioner had really been part of her registered properties or of the respondent's property. The proper resolution of such dispute in favor of the respondents could be had only after a hearing in which the trial court was enabled through preponderant proof showing that, indeed, the disputed area was not within the metes and bounds appearing and stated in the TCTs of the petitioner. We reiterate that a boundary dispute cannot be settled summarily through the action for forcible entry covered by Rule 70 of the Rules of Court. In forcible entry, the possession of the defendant is illegal from the very beginning, and the issue centers on which between the plaintiff and the defendant had the prior possession de facto. If the petitioner had possession of the disputed areas by virtue of the same being covered by the metes and bounds stated and defined in her torrents titles, then she might not be validly dispossessed thereof through the action for forcible entry. The dispute should be properly threshed out only through action reivindicatoria. Accordingly, the Municipal Circuit Trial Court acted without jurisdiction in taking cognizance of and resolving the dispute as one for forcible entry. Given the foregoing, the Court of Appeals committed reversible error in affirming the judgments of the lower courts and in ordering the summary ejectment of the petitioner from the disputed area. Considering that the remedy availed of by the respondents as the plaintiffs was improper, the court need not discuss and settle the other issues raised by the petitioner. Wherefore, the court grants the petition for review on certiorari reverses and sets aside the decision of the Court of Appeals, dismisses the complaint for forcible entry without prejudice to the filing of the proper action, and orders the respondents to pay the cost of suits. Usika sa oras, no? Imagine na kano saan inigawas ang desisyon. Ya sa'yo pang remedy nga na-file. May nalagay, pwede ma-refile, pero imagine ang time, gasto, ang effort, nigawas ang desisyon September 2019. Na-file ang kaso, kinagsugod pa ang Municipal Circuit Trial Court, naabot ang Regional Trial Court, Court of Appeals, niya Supreme Court. Imagine, unsa nakadugay, ano kanina file? Na sa decision, Municipal Circuit Trial Court, yung decision 2014. Nigawas ang kaso 2019. Paspas good. In its decision dated 2014, the Municipal Circuit Trial Court ordered petitioner, among others, to vacate. So 2014, na-file siguro ni kay ang katong act the alleged forcible entry around 2010. In fairness, naabot sa Honorable Supreme Court na desisyonan 2019 ang entry, alleged illegal entry, alleged lang 2010, dapita more or less. Siguro ni file ni 2011, manibutang diri unsang tuiga na file ang complaint. Na desisyonan 2014. Aspas. Considering nga gikan sa MCTC niadto pag-appeal sa Regional Trial Court, niadto pa sa Court of Appeals, inabot sa Supreme Court, na desisyonan sa Honorable Supreme Court 2019. Hindi kay dugay. Na hope. Paspas, no? So basically, ang concept dire, ang doctrine dire nga, the resolution of a boundary dispute by reason of the issue therein, being whether or not the contested portion pertain to one or the other of the parties, is not within the scope of a summary action of forcible entry under Rule 70 of the Rules of Court. Dapat dili forcible entry mo i-file. Ang imo i-file, action revindicatoria, no? Pero di makini novel nga doctrine, mangita tagkaraan niya kaso aniha. Nindot sa. Pero at least na-clarify ba? 2019 ba nga decision? Di pa kay karaan. Okay? I'll see you in the next video.